Dear viewers, this is our Tuesday episode of Expert Speaks. Today we are taking up one important subject. What if you were to be incapacitated during your life? You are medically unfit, you cannot discharge your financial responsibilities, things that need to be attended to, you are not able to do. How can you solve this particular problem? We are talking to our expert of the week in this episode to give you an answer what exactly you can do about it. This is NRI Money Clinic for you, and I am Dr. Chandrakant, your financial guide for a happy living.
NRI Money Clinic. No hype, just the right advice.
Dear viewers, to talk about the issue of how you can solve this problem of in case if you were to be unfit to discharge your responsibilities during your life because of a medical condition, how that problem can be solved, I have invited for this episode my eminent faculty, Miss Aditi Joshi. Miss Aditi Joshi is a lawyer with 12 plus years of experience in estate planning and commercial law. Previously, she has worked with the Bank of Tokyo. She has also worked with Kotak Mahindra Trusteeship, MUFG Bank, and Paras, Kuhad and Associates Advocates. Her areas of specialty include consulting on will creation and structuring trust. She is the head of legal currently with Yellow in Bangalore. Welcome to the show, Ms. Aditi Joshi.
Thank you so much, sir, for having me over. Thank you for your kind introduction. And as always, looking forward to have a very good discussion on such an important topic.
Aditi, just before we get started, I thought of calling you again for this episode. Your earlier episode on nomination is well received by the audience. There were lots of questions. A lot of people messaged me. They have sent in a lot of appreciation for your earlier works. The topic that you need to give us solution today is what if somebody were to get medically unfit during their lifetime and they are not able to discharge their financial responsibilities, they are not in a state of mind, they could be going into the comas, they could be in terminally ill status, anything could happen. One accident can completely derail one's life, and we have seen what happened during the pandemic. These are not odd cases. You encounter such cases very often. In fact, I had one client from my overseas portfolio there and who suffered this kind of a problem since 2016 until date. He is not out of it. So it's not a rarity, and everybody who is watching this episode should take this issue quite seriously, and it is very essential. See, everybody knows about how a will is getting created. Everybody prepares for what happens after my time, how the assets have to be distributed to the nominees or whom I want to. But what happens in case if I'm still living, but I cannot discharge my duties? Over to you, Aditi.
Yes. As you very rightly mentioned, sir, that, this is a topic which is very sensitive because now we're touching upon situations where a family member is not well. And how do you deal with this? But, before we come to this fundamental topic, let's understand what is the difference between a living will and a regular will, because today in India, living will is not really a household term, not very frequently known. Now, essentially, when you talk about a living will, it's also known as an advanced medical directive. What this means is that via a document, you list down what are your preferences regarding any medical treatment that should be, imposed upon you. Now, the reason I use the word impose is because there are certain situations in which a person can be terminally ill. And in this document, you list down that, look, I don't want to be kept on a mechanical ventilator. I don't want to be tube fed. Other complicated life revival processes should not be inflicted on me in case my disease is irretrievable. So while this document, it serves as a guiding light, not just for doctors, but also for family members when they have to take certain decisions. Now, let's understand what a regular will is. A regular will basically means that in this document, you list down how your assets are to be distributed. So in this regular will, you can list down about who your family members are, who should get how much assets. You can mention about guardianship of minor children, funeral arrangements, etc. But it's very important to understand that the purpose of both a regular will and a advanced medical directive or a living will are very different. Advanced medical directive is only to take certain medical decisions, and your regular will comes into effect only after the death of a person. So it's important that both these are separated, and you should not get very confused about this topic.
So while we use the term will, there is a will to be exercised post-demise, and we are talking about will, which is a living will. Is my understanding correct, Aditi?
Absolutely, sir.
Aditi, when you talk about living will, in India, it's a subject which is not being discussed, not there is enough data or enough public awareness. I even do not know whether there is a codified law which speaks about a living will. And it's a complex subject. You are a legal person. Is there a law which talks about this living wills in India?
So that's actually a very good question, sir. Now, to be honest, today there is no specific codified law governing, living wills or advanced medical directive in India. Now, let's first understand fundamentally, living wills basically they accelerate the process of death. What this means is that basically when a person is actually already in a state where, the process of death has started, what we're now trying to do is we're trying to, stop the treatment so that the process gets over soon. Obviously, death is such a sensitive topic. This has itself given birth to various questions. For example, to what extent should this be even allowed? What if there's a misuse? Can a person who's simply depressed claim this particular right to die? Now, let's say a doctor who's, accelerating this process of death. Can it mean that the doctor is actually aiding in the suicide of a person? Because we have laws in India which punish suicide. So, even when we're talking about living wills, it's very important to understand this fundamental concept of euthanasia, because euthanasia basically means that mercy killing, as in common parlance, we've seen it. So, euthanasia can also be of two types. One is active euthanasia, that is, our doctors are actively injecting something in, let's say, a terminally ill person to basically stop the survival process. Now, you have passive euthanasia, which basically means that the doctors are simply withdrawing life support, or they are not taking enough steps to preserve the life of a person. So, the important difference between active and passive euthanasia is that in active, you're taking some steps to sort of, seize the life of a person. But in passive, you're simply not doing enough so that the life is preserved. Now, the legal position across the world is active euthanasia is illegal unless you have a proper law which governs it. Whereas passive euthanasia is legal even if there is no law, but certain steps and protocols have to be covered. Now, consent becomes very important here, because whether it's active or passive, consent can either be given by the person itself on whom this euthanasia is to be performed, or of course, consent can also be implied, that is where the family members come in. Now, this whole aspect of suicide also becomes important because the courts in, again, across the world, they've much discussed this topic. And now they've held that just because a doctor is withdrawing life support, it does not mean that they are helping in suicide, because what they're simply doing is they are accelerating the natural process of death which has already begun. While we're on this topic, even the impact that this has in a society, it can't be ignored, because in the absence of a advanced medical directive, there's immense pressure on the family also. How does a family decide whether they should pull the plug or not? Also, there's always a certain amount of guilt, when it comes to a family, like you mentioned, right? Like, of an NRI who went through this, because the family may always feel, what if the person who's undergoing the illness doesn't want to sort of pass away? There's also one element that is there also maybe, an abuse by the beneficiaries in certain cases where they want to just inherit property of the person who doesn't survive. So honestly, there's a lot of complex, aspects to be involved. And because of that, there have been efforts made by the Law Commission of India to sort of form an act on this. There is a medical treatment of, terminally ill patients bill that was there. It was first there in 2006, and then another one was submitted in 2012. But again, the Ministry of Health was not sort of in favor of enacting it, because one fundamental conflict is that, doctors take an oath that they're supposed to preserve life. And this is sort of against that. What the Ministry of Health also had a concern that the medical science has progressed so much today. So again, is this going to be in conflict with that? And what if the patient really doesn't even understand? Because obviously, doctors are in a better position to understand these aspects. So, taking into consideration all of these complexities, the Supreme Court of India, in a landmark 200-page judgment in Common Cause versus Union of India in March 2018, held that the right to die with dignity is a fundamental right that is enshrined in Article 21 of our Constitution. And the Supreme Court primarily understood that, yes, with the advancement of, modern medical technology, a situation has arisen where the dying process is sometimes unnecessarily prolonged, and this causes a lot of distress and agony to the patient and also to the near and dear ones. And that is when, for the first time in India, they recognize the importance of an advanced medical directive.
Aditi, very interesting perspectives. On one side, the person who is making a living will is looking to benefit from it or looking to reduce his burden of living without a hope. On the other side, the complexity comes in the form of what does the law of the land say? What does the beneficiary, the intention of it is somebody is trying to make a profit out of it, somebody is trying to make misuse of the whole system. It's pretty complex. It's definitely complex. There are no easy answers around that. Checks and balances have to be there, and finally, the integrity of the individuals, which is the biggest safety in this particular case. Now, coming to the real execution of living will, if somebody is interested to give this advanced medical directive, what are the steps that need to be followed? Can you enumerate for the benefit of my viewers what they can do and how they can do about it?
So, it's also interesting to share over here. In March 2018, the Supreme Court listed down various, guidelines and procedures to be followed. And to be honest, practically, they were very, very onerous. So there was an application which was again filed, and the Supreme Court revised these guidelines as recent as January 2023. So, today to execute a living will or an advanced medical directive, one needs to be 18 years of age. They should be of sound mind. The AMD should be made obviously free of any coercion. Now, over here, the person who's executing the document is called as an executor, and they are required to appoint a guardian who's basically authorized to, refuse treatment. Now, this living will is supposed to be hand signed by the executor. Digital signatures are not allowed. And you need to also have two independent witnesses do the same. Now, there are some additional steps to sort of, that's where the safeguard aspects come in. Living will must be attested by a notary or a gazetted officer. Now, the notary as well as the witnesses also need to record their satisfaction in that particular document itself that this living will was executed without any coercion. And there are a couple of other aspects. You need to hand over, a copy of this to the guardian. You also need to hand over a copy to the family physician. Now, one additional complex procedure here, that is where the trouble starts, is that you also need to hand over, one notarized copy to the custodian, which is designated by the municipal corporation. Now, I'll tell you a practical aspect, a case here. There's a Mumbai-based doctor, Dr. Datar, um, who's very huge propagator of advanced medical directive, when he created his own AMD and he approached the municipal body, they were not even aware of such a clause. They literally told him, you check the website and, this and that. However, being fed up, he actually posted a copy to the municipal commissioner. And recently it was again in the news. He said, it's been 8 months and I still don't know where the document is. See, this acting of a custodian is important because the Supreme Court said in the guidelines, one notarized copy needs to be with the custodian, because when the family is handing over this AMD, the hospital needs to cross verify that same copy with the custodian of the municipal body, so that they know these are the same copies and there is no sort of misuse or abuse over there. Now, even with the challenges, the process that is today is comparatively simpler to the earlier process. Now, the earlier process, the living will was to be countersigned in the presence of a judicial magistrate of first class. And there were additional protocols that were needed, like JMFC was supposed to preserve one copy and preserve one copy in digital format and forward one copy to the registry. It was a huge hurdle to sort of even get to execution of this. Again, it was in the news that in Chandigarh, one couple took almost 9 months to only get this AMD countersigned in the presence of a judicial magistrate. There are certain challenges even at the implementation level today. For example, let's say if a family has created an AMD and the hospital is supposed to honor that, they have to first form a primary medical board. There's certain qualifications which are prescribed by the judgment. After that, it goes to the second medical board, and depending on the decision that they make, still permission of the judicial magistrate is needed. And if the family is not in line with what the board has said, they can go to the high court. So even today, practically, there are a lot of challenges in order to get this implemented. But we're hoping that, with time, it will get much simpler.
Aditi, very, very interesting perspective. Yes, there is a good intention. The purpose behind is to reduce the suffering, giving it easy, respectable exit to a person who has lived long. But it takes time. The whole system also has to be geared. I don't even blame the authorities or anyone there, because these are rare cases, and it's not something that is there at every you do like a notarizing a copy. That's not the way it happens. So it is in the infancy of its the lawmaking currently. Can you, for the benefit of my viewers, tell me what's the status of similar living wills in other countries now?
Sure, sir. So, in most developed countries, the process is relatively simpler. Example, in UK, you just need to sign it and have one witness to the same. They can also, share this AMD with the NHS, which is the health body there. And they also have a proper codified law on this topic. In Canada, the living will can be signed in the presence of two physicians. In many other countries, this decision can also be made on the basis of a medical power of attorney, which is not accepted that much in India today. So the process is relatively simpler. And, the number of people making it itself shows the acceptance of this particular topic. For example, nearly 37% of the Americans today actually have their advanced medical directive.
Aditi, so if it has captured so much of an attention in a developed country like US, where you say that 37% of the general population is covered on AMD, it's just a matter of time, a developing country and a large chunk of Indian population, which is moving from to the richer categories right now, they too will take time to move forward on these things. So what do you suggest for the viewers of this channel? Should we wait for more clarity emerging in India on this will side, then you execute? Or, on one side you don't have a will, or you have something else at least to support you. How should the viewers take this subject forward? What's, as a practitioner of law, and you are also in the line of inheritance, will creation, this is what you do day in and day out. What's your message to my audience?
Again, very, very good question. This often poses as a dilemma for people, that despite the challenges, should we go ahead or not go ahead? But in our view, it's always better to have some document in place rather than nothing at all. See, this document reflects what is it that you truly wanted, and in our view, it can most definitely avoid the unnecessary suffering in case there's a terminal illness. Also, from a family perspective, with an AMD, decisions will be much easier for the family members, and there'll also be less disputes, because if one person is say let's not pull the plug, the other will say let's do it. So it has, we've seen where families have been broken because of such decisions. So for mental peace of mind, yours as well as your family members, we definitely recommend you to have one. Now, along with a living will, make sure to also create your regular will, because, like I covered upon this earlier, both these documents are very separate. The purpose is very separate. Please don't turn it into one consolidated document, because, as you know, living will purpose is different, the method of execution is different, whereas a regular will comes into effect only after that. So just prepare two separate documents, and make sure that your interests, your family's interests are completely taken care of.
Thank you, Aditi. Indeed, it's an eye opener, and nobody thinks about it till they actually reach that particular stage, or sometimes in life it so happens. As I mentioned, the case of one of our clients where the suffering is unbearable and there is no end to it. And everybody prays that how this suffering can be brought down. But there is a solution right now. Thank you very much for drawing the attention of my audience towards this particular subject. Thank you very much for your kindness, your time, and sharing your knowledge with my audience. And I remain in gratitude to you for all this kindness. Thank you very much.
Thank you so much, sir, for having me over, and we're looking forward to having more engagements on your value channel.
Sure, sure. Dear viewers, hope the topic that we have covered in this episode with the expert of the week, Aditi Joshi, helped you to understand and answer that critical question that could be there in your mind. What happens if I'm not medically fit, and what might happen, and how I can come out of it? What's the legal remedy? What steps I have to follow? If it did give you a direction, the way you have to take in the next steps of your life, please do give me a thumbs up. Do not forget to hit that subscribe button if you have not done it already. Do press the bell icon. You will be notified whenever I release a video. Do not forget to share these videos with your friends and relatives. Thank you very much for watching this episode on NRI Money Clinic. I shall be back with you next Tuesday with yet another useful topic, with yet another expert. Till then, stay safe. Jai Hind.
Press the bell icon for more details and subscribe our channel.